Swayam Prabha. Digital India. Educated India.
I am Dr. Surendra Mehra, Assistant Professor, Law Department, Banaras Hindu University, Varanasi. So, this is my 9th lecture on various provision of appeals under Code of Civil Procedure 1908. Appeal, basically you can call it appeal. First appeal we have, second appeal we have, appeal to Supreme Court also we have, third appeal you can call it appeal to Supreme Court. Section 96 deals with first appeal, section 100 deals with second appeal, and section 109 deals with appeal to Supreme Court. Apart from this appeal, also we have different other remedy, like we have revision 115 and review 114. So, what I have seen, student get confused also with this word, when to file appeal, when to go in revision, when to file review, or what are the authorities basically before whom we should or we can get benefit of these provisions. Appeal before whom court, I mean to say first appeal before whom court, before which court, second appeal before which court, appeal to Supreme Court definitely before the Honorable Supreme Court, or third appeal, revision before which court, review before which court. So, they get confused also sometimes, they ask number of times this question. So, if you attend this session, although this session is on appeal, I will cover first appeal, second appeal as well as power of appellate court. Although I have mentioned all provisions here regarding appeal, first appeal, second appeal, appeal to Supreme Court, as well as appealable order, order 43, appeal by indigent person also. Just for your understanding, you can get the entire appeal material in this one lecture itself. So, this is otherwise also this is very important topic, appeal. So, before discussing other things, first of all I think we should understand the meaning of appeal. Before discussing first appeal or second appeal, we should understand the first appeal, the meaning of appeal basically. Appeal, as this is visible from this first PPT itself, this is the judicial examination of the decision by a higher court of the decision of an inferior court. You can call it judicial examination, you can call it judicial re-examination, but this is, I will say, this is the examination of your decree, or this is the examination of your order. If you are filing any appeal against the decree, or there are appealable orders also simultaneously. So, this is judicial examination. What does it mean, judicial examination or judicial re-examination? Judicial examination means like what I have told you in section 9 also, or otherwise in other session also. On the first date of hearing, court examines basically, or during the entire trial court examines the suit so far as the trial is concerned. Here before the appellate court are also doing the same thing. If you are not satisfied with your decree, if you are not satisfied with your order of the lower court, decree by the this original court, if you are not satisfied, if you have any sort of dissatisfaction, then you can approach the appellate court, first appellate court, second appellate court. Accordingly, although second appeal is on substantial question of law, third appeal is again on substantial question of law and question of general public interest. But here we are discussing only the meaning of appeal. You have to keep, again I will say this one, you have to keep the entire picture of your trial in your mind, because I am telling you this is judicial examination. Court will examine the appellate court, or in your original case the lower court will examine your plaint, court will examine your written statement and further evidence, statement of witnesses, this is examination by asking question, by getting evidence, accepting or appreciating evidence. Here the appellate court is also doing the same thing, because this is the power of the appellate court. The question is whether you have a right of appeal or not, because this is statutory right, this is not inherent right. There is a PPT also on this point, the difference between right to suit and right to appeal. Right to suit is also, I mean, in case of right of suit also the court is examining, in case of right of appeal is also court is examining, but right to suit is your inherent right. You get this right by birth. If you have any sort of grievance, any sort of problem, if you feel your legal right has been violated, you are aggrieved one, then even for a small amount you can approach you can file civil suit. But so far as appeal is concerned, this is statutory right, unless and until your statute provides it, statutory right, unless and until statutes provides this right. That is the reason the relevance of section 96, first appeal, section 100, second appeal, substantial question of law you have to find out if you want to approach the high court. In case of first appeal, if you want to approach the appellate court, the first appellate court, that can be even lower court also, appellate court, then also you have to find out whether this is falling within section 96 or not. So, this is judicial examination by the higher court. Higher court or the appellate court will examine the authenticity or the validity or the soundness of the decision what has been given by the lower court. Higher court will examine, appellate court will examine, judicially examine the decision, whether there is a all evidence has been appreciated by the lower court or not, whether issues has been framed by properly or not, whether there is a preliminary disposal or not. All those things, what sort of grievance you have, you can mention in your memorandum of appeal, and appellate court will examine, judicial examine, judicial re-examine also you can call it, judicially examine the decision of the lower court. Although there is a principle in section 11, judicial decision must be accepted as correct one, but that does not mean that if there is a violation of your legal right, if there is a violation of your you find your evidence has not been appreciated by the court, if you find no, lower court has committed this error, although you pointed out but the court did not appreciate it. If you are not satisfied, then you have to find out. If you are not satisfied, then definitely this will give you this right, and you can go in first appeal, you can approach the first appellate court. So, this is judicial examination of the decision, and further also the same thing has been written, is given by the statute and by rules having the force of statute. Unless right of appeal is given by statute, it does not exist. So, this is a statutory right, you have to find out in section 9 whether this is a, otherwise for every matter, I mean, you cannot approach the appellate court. Section 96 will read and will come to know more about it, this one ki how, what does it mean, whether this is statutory, how this is statutory right, and you will come to know simultaneously with the inherent suit also. Right to suit is your inherent right, how this is inherent right. So, basically here this is the dictionary meaning, but otherwise also the meaning is same one. When appellate court examines your decree, what you have got from the lower court, the order what has been passed during the pendency, during the trial of the case. So, against all those things, against decree is although is final one, but appeal is always open. If you find there is a provision of first appeal or not, you have to clear this one, you have to in advance you have to know this one. So, this is judicial examination of the decision by higher court. Although this word has not been defined, these are few judgment also, you can go through this judgment and you will get the idea and definition or meaning of this word appeal. These are the essentials. First one, a decision, usually a judgment of court or ruling of an administrative authority, judgment of a court or order also, you can add order also here, judgment of a court, decision, these are the essentials. For this, without this you cannot, because this is not a inherent right, This is not right to suit, this is appeal. You are approaching the appellate court, and appellate court is the higher court, not high court, higher court. Second one, a party or person or aggrieved, whosoever is aggrieved by such decision, a reviewing body ready and willing to entertain appeal, this is something else, but these 2 points are very important. Judgment as well as order, decree or order. Judgment means, I mean subsequently you get decree, so that is the reason I have mentioned here only judgment, but you have to understand this is decree and order, and the party aggrieved, whosoever is aggrieved, they can approach the appellate court. Who can? These were the essentials, and these are who can prefer. In case of death of party, his legal representative also, because these are the parties, any party to suit adversely affected by the decree, whosoever is affected, legal representative. In case of minor, guardian of the aggrieved minor, they can approach the appellate court, because there must be some local standi, otherwise court will not entertain your appeal. Any transferee of interest of party who is bound by the decree of the court. So, it does not mean that only the party who are affected by the decree, legal representative or aggrieved minor, guardian of the aggrieved minor. Apart from this also, if you have interest in decree, if you are affected, this also comes within this purview of this one. If you are affected, if you have interest, then you can also, by getting permission, you can also, the third party also. Third party means whosoever has an interest, whosoever is being affected by the decree, they can also approach the appellate court. A person who is not a party to suit, but who is aggrieved by decree, who is prejudicially affected by the decree, but such person must receive leave of appellate court to file appeal. This is what I have told you, permission of the court, and you have to show before the court how you are concerned with this case, how you are being affected by the judgment or decree, how you are affected, what kind of interest, how you have a locus standi. You have to show that. It means this third person also can file or approach the appellate court. This is the distinction what I have already told you, fundamental distinction between right to sue, right to file a suit and right to file an appeal. Right to suit and right to appeal. This is a right to suit is an inherent right. I hope you understand this one, the meaning of inherent. What you get by birth, nobody can stop. If you have any grievance, this is civil matter. If you have any problem, if you feel somebody has violated your legal right, then this is your inherent, no need to see any provision, but the thing is the right must be legally enforceable. What I was telling you earlier in earlier session, because there are some people get confused, sometimes students get confused with social rights and legal right. They consider even social right also, this is also legal one. No, the right is not a legal one. You have to find out. If you have studied law properly, your substantive rights properly, then you can easily come to know. I was also giving example earlier in earlier session, like helping out someone on street is not your legal right. This is kind of moral obligation. If you help somebody out on the street, then this is your question of this is your sanskar, this is your good behavior. But that is not illegal right. If you do not help him out, then the party to whom you are not helping him out cannot file suit against you. So, you should understand this difference for this understanding this inherent, how this is inherent right. If the right is legally enforceable, then you have inherent right, you get right by birth, you can approach the appellate court, no need to ask anybody. The right must be legally enforceable, because on the first date of hearing, court will examine this one whether there is a cause of action or not. Cause of action means the same thing, otherwise court will reject order 711. Whether there is a cause of action, bundle of essential fact, meaning of cause of action. This is the meaning of cause of action, bundle of essential fact, whether there is a legal cause of action or not, whether this is legally enforceable or not. Court will examine you on the first date of hearing itself. If there is no cause of action, then court will reject your application. This is what every person to bring a suit of a civil, but the position in regard to appeal is quite the opposite. The right of appeal is a statutory right. Here you have to find out whether this is statutory one, because section 96 will tell you, 94 will tell you this one, 96 not 94, 96 will tell you this one, how this is statutory right. because there is a clear cut provision against the decision of the small causes court, except on a question of law. If your value is not exceeding 10,000 rupees, then you cannot go in appeal against the decision of the small causes court. But on a question of law, the appeal is open, first appeal is open. Apart from it also, against consent decree there will be again no appeal, but against ex parte decree there will be appeal. So, this kind of this is section 96 what is telling, because this is telling you how this is a statutory right. So, right to suit is a inherent right and right to appeal is a statutory right. Do not get confused with these two words, how or for every case or for against every decree or against every order. If you feel no, let us approach the appellate court. If there is an order, then see order 43 in CPC. There is a list of appealable orders, clear cut 10 or 20 grounds are there. Those orders, against those orders you can approach the appellate court, otherwise always orders are final one. I have discussed this difference between decree and order session also, the lecture on decree and order. Orders are always final, but there are few orders which are appealable. Decree is always final, so every decree is appealable, but orders are not, every order is not appealable one. These are the kinds of various provisions I have mentioned on my first slide itself. These are the various provisions, although I will discuss few things, but just for your understanding I have kept this is appeal from original decree. You can write it first appeal. Original decree means first appeal, first appeal. Second, appeal from appellate decree or second appeal, section 100, second appeal, appeal to high court. First appeal before the appellate court, whosoever is higher in that hierarchy. Second one is second appeal before the high court. Third appeal, appeal to Supreme Court, section 109. Appeal from order, section 104 or order 43. Appeal by indigent person, order 44. These are the various provisions of appeal in our CPC. This is appeal from original decree or first appeal, you can write again, section 96, first appeal. See this provision, how this is a statutory right, appeal is a statutory right. You can note, an appeal shall lie from every decree passed by any court exercising original jurisdiction, the court authorized to hear appeal from the decision of such court. Against every decree is appealable, and all those points of decree must be there, what we have discussed earlier. Conclusive determination of your right, right of party with regard to all or any of the matter in controversy, must be adjudication, substantive right of the parties, formal expression. If you feel still your some sort of right has been violated by the court or this violation of law, then if you are not satisfied with the decree, then you can approach the appellate court. An appeal may lie from an original decree passed ex parte, order 9, rule 6 is called ex parte, and rule 13 is this, how you get this right. An appeal may lie from an original decree passed ex parte, order 9, rule 13. For this you can see there are 4 remedies available against this ex parte decision. Ex parte decree, ex parte decree means one sided decree, when defendant is not coming, defendant is not appearing after serving notice, sometimes after serving notice, although there are 3 provisions, not someone served or not served, all those things are there. No appeal shall lie from a decree passed by the court with the consent of parties. If there is a decision based on mutual understanding, normally what happens in Lok Adalat, the parties mutually together decide their case. Court, you can also get referred your case from the original civil court before the Lok Adalat, from original civil court to Lok Adalat. Then there you decide it with the help of the, mutually you decide it. Together the parties sit together and they decide it, whether they are happy with this decision or not, and then they get it recorded from the Lok Adalat, and finally they get a decree on that point. So, against that consent decree there would be no appeal, no appeal, word is here, no appeal against ex parte decision, ex parte decree, this consent decree. Against consent decree or decree which has been decided mutually, then there would be no first appeal. Fourth one, this is very important, these are very simple thing, first, second and third one, and I am telling you simultaneously with this first appeal section 96, like how this is a statutory, this is statute, section 96 is a part of statute and telling specifically CPC, if this thing is there only then appeal is there, otherwise appeal is not there. But for right to suit, because right to suit is a inherent right, everybody has right, even minor has right, even person of unsound mind has right, but for that no doubt they need an ex friend and guardian. Indigent can also file suit, but for that no doubt, I mean they can get exemption from the court fees if they do not have money, but minor and person of unsound mind can also file suit with the help of guardian and an ex friend, order 32. So, this is statutory one. No appeal shall lie except on a question of law. Here you have to mark, this point is very important, and this one, original suit does not exceed 10,000 rupees, earlier this limit was 3,000. No appeal shall lie except on a question of law from a decree in any suit of the nature cognizable by a court of small causes, when the amount or value of the subject matter of the original suit does not exceed 10,000 rupees. No appeal shall lie except on a question of law. It means there can be appeal on a question of law against the decision of the small causes court. Small causes court means which is deciding the small matter, the petty matters, not that much important. Value has also been mentioned here, 10,000 rupees. Earlier this limit was 3,000 rupees. Now the limit is 10,000 rupees. So, question of law, this is what you have to understand. What is the difference between question of law and question of fact? I have mentioned earlier also in the lecture decree and order, but just again for your convenience I will mention it here, repeat it here. Question of law, there are two questions, because on the basis of the plaint and return statement court frames issues, and issues can be of two type, issues of law, this is issues of law means question of law or matter of law, and questions of fact, questions of fact, question of fact, this one, questions of fact. On questions of fact there would be no first appeal against the decision of the small causes court, keep it in mind. There would be no first appeal, again I am repeating, on question of fact, but question of law there can be appeal. Question of fact, because the matter is already petty and small one, if the limit is not going beyond 10,000 rupees. Up to 10,000 rupees there would be no appeal, first appeal against the decision of the small causes court, against the decision of the small causes court. But if there is a question of law I have already given examples like jurisdiction related issue, again I am writing it, jurisdiction related issue, this is question of law, jurisdiction, question number 1, or barred by law, barred by any law, this is question number 2, this is question number 2, question of law, this is question of law, jurisdiction as well as barred by any law. This is example, otherwise also you can come to know any other question of law can also be there, depends on the court through memorandum of appeal, through plaint and written statement. Here because we are in appeal, so through memorandum of appeal court can come to know whether there is a question of law or not. If the court has jurisdiction related issues, you can come to know like whether this particular court has jurisdiction, authority to decide this matter or not. Then there can be, except on a question of no appeal shall lie except on a question, then there will be appeal if how the lower court or small causes court has decided this case, because question of law was involved there. Jurisdiction, whether the small causes court had jurisdiction or not, whether the small, I mean the matter was barred by law, but still lower court or small causes court has decided the matter, because we are in appeal. This is, if this thing is there, then definitely you can plead it before the appellate court. The small causes court has decided the matter despite or by just by bypassing or overlooking this question of law. because a decree always, this is the fundamental principle of civil law, general principle of law, civil law. A decree passed by, you can write it also, a decree passed by a court without jurisdiction is null and void. A decree passed by a court without jurisdiction is null and void, and validity can be challenged even in collateral proceeding also, even in execution proceeding also, validity of that judgment. So, do not conceal anything, you cannot overlook, you cannot bypass any law, because this issue is very much crucial one, jurisdiction, whether lower court or small causes court had jurisdiction or not. So, if this thing has been overlooked by the lower small causes court, then this itself can become a ground of first appeal against the decision of the small causes court. Otherwise, this will be, judgment will be void, opposite party any time, or anyone whosoever has an interest any time can raise this point before another court, how lower court has committed this error, or second one is barred by law. These two grounds you will find in order 14 also, rule 2 itself you will find, these two examples has been given over there also. So, against question of law or on question of law, but there will be no second appeal on question of fact against the decision of the small causes court. And what is question of fact? Already told you, question of fact, you are relating your the cause of action, whatever your relief, whatever plaint or whatever fact you are bringing before the court, but first court will decide this one and then second question of fact. First court will decide if these both points are there, then first court will decide this one and second court will decide this one. Otherwise, when the amount, or there can be appeal also against the decision of this small causes court when the original suit is exceeding 10,000 rupees, then also there can be appeal against the decision. Otherwise, there will be just one funda you have to understand, we are talking about small causes court. Small causes court basically decides small matters, petty matters. So, that is the reason we have curtailed this right of appeal and we have made through statute, we have made it compulsory, like only on question of law there can be appeal against the decision of the small causes, otherwise there will be no appeal, but if amount is crossing 10,000 rupees then there can be appeal even on question of fact also. This fourth point you have to understand specially, and how this is statutory one, this is first appeal. So, second appeal is also on substantial question of law, second appeal, section 100 deals with basically substantial question of law, this is substantial question of law. Memorandum of appeal, even in first appeal also, before the first appellate court also, before the second appellate court also, you cannot go without memorandum of appeal. Your memorandum of appeal, we do not call it plaint, we call it memorandum of appeal. You are drafting your grievance, whatever you are writing along with the decree. You mention specially the problem, the how you are not satisfied, on what things you are not satisfied with the decision of the lower court, that is called. But here in second appeal only substantial question of this one is important. Substantial question of, what is substantial question of law? In one line, although there is a case, Chunnilal Mehta versus Century Spinning Mill and Company. Chunnilal Mehta, this judgment is very important. Chunnilal Mehta versus Century Spinning Mill and Company. Chunnilal Mehta versus Century Spinning and Company. You must read this one, Century Spinning, Century Spinning Mill, 1962 judgment. Chunnilal Mehta versus Century. In this particular case, this word substantial question of law has been divided. I have seen number of students are committing, they are confused with substantial question of law and question of general importance. These two grounds are there for the appeal to the Supreme Court, but substantial question of law in one line meaning or in one line sentence I will say, if it affects your right, that is a substantial question of law, that is a substantial question. Otherwise, your second appellate court or the Honorable High Court will not accept your second appeal. First appeal, no doubt you can go as per section 96, but second appellate court or the Honorable High Court will not accept your this one, You cannot call every question this is substantial one. You cannot call every question this is substantial one, but the meaning of substantial question is if it affects your right. How it affects your right, you have to justify, the concerned party has to justify how this is substantial one, because you and me basically understand this one. Sometime you even point out some small things also before the court, this is substantial, how this is substantial. So, this one you have to formulate it accordingly in memorandum of appeal, precisely state the substantial question of law involved in the appeal, and you can. So, first appeal as per section 96, second appeal on substantial question of law. In this case, you will get the entire idea. The crux of this case is only this one line meaning, which affects your right of the concerned parties, which is substantial one, which is crucial one, which is material one, which is important one, that is substantial, and this varies case to case. Is this also I have mentioned here. But for on appeal to Supreme Court, question of general public importance, you have to make this difference. These 2 points must be there, both 2 points, substantial question of law and general public importance, but for second appeal only substantial question of law, not question of general public importance, and you need certificate for appeal to Supreme Court, in case of third appeal. This one, substantial question of law, this one, substantial question of law of general importance, this one, these 2 points must be there. These are appealable orders, order 43, I already told you, rule 10, order 7, returning a plaint, this is appealable order. If this order is not there, then you cannot. Rule 9 of order 9, rejecting an application, rule 13 of order 9, rejecting an application, rule 21 of order 9, non compliance of order of discovery, section 35A, compensatory cost for false or vexatious claim, these are appealable orders, otherwise every order is not appealable one. Section 96 or 92, section 95 and different other things. You can go through 43 and you will come to know what is appealable order, whether your order is appealable one or not, otherwise do not approach the court. These further few things are also there. These are appealed by indigent person. In order 43 you have order 33, you have read there is a provision suit by an indigent person who is a poor one, indigent person. I have given the complete definition of indigent, who is not having sufficient means or who is not having even worth property of worth 1000 rupees, if no fees is prescribed, that you need application or you need this status, court will grant you status as per order 33. But here the provision is of appeal by an indigent person, 44, order 44 of CPC. This is power of appellate court, whether first appellate court or second appellate court, these are the powers, and this is very important. So far I have discussed only the meaning as well as different provisions of appeal, first appeal, second appeal, appeal to Supreme Court, appealable order and indigent appeal by indigent person, but this is very important. Section 107 specifically decides, or I mean lays down these provisions, what are the power of appellate court, how and what power can be exercised by the appellate court. Very I mean you have to pay attention over there. One first power is power to decide case finally, no doubt, this is very easy. Second, power to remand. Remand means send back case, again before the lower court, but this power is very rare one, again before the lower court, send back. So, you can power to remand, this is very interesting one. When the lower court dismisses the suit as being not maintainable, or you can call it when the lower court dismisses your case on a preliminary, disposes your case on a preliminary point of law or fact, preliminary point, preliminary, this is what you have to understand here, preliminary point. Preliminary point can be of law or can be of fact. when lower court decided your case, because now you are before the appellate court and you are asking for the power of remand. Remand means sending back the same case again before the lower court and directing the lower court to try it again, because you have committed this error. So, this is very rare power, this is very special power of remand. When this would be exercised by the appellate court? When lower court dismisses your case on the basis of the preliminary point, disposes your case, preliminary point of law and preliminary point of fact. Here are few examples. What are preliminary point of law? Power as being not maintainable or barred by any limitation, res judicata, as disclosing no cause of action, it does so on a preliminary point of law. Mark it from here, you will get this material in your books also. Dismisses the suit as being not maintainable. Suppose you wanted to give sort of evidence, you wanted to prove your case, but the lower court said no, this is not maintainable, there is no cause of action. Sometime ultimately court has to appreciate your plaint, court has to, lower court or before whom you are, the court has to appreciate your plaint, written statement, your all evidence, primary, secondary evidence, your cause of action. Sometimes lower court commits this kind of mistakes also. It is a question of how advocate is arguing before the court. If advocate is not able to convince, then court can easily reject or dispose your case just by saying this one, the suit is not maintainable. Res judicata, section 11 of CPC. What it does it mean? What does it mean? Res judicata, when matter has already been heard and decided by the court, then no further litigation, because judicial decision must be accepted as correct one. The decision is already on merit. Again, it is in the interest of state that there should be an end to a litigation. This is the base of section 11, res judicata, even res sub judice also, section 10 also. You wanted to give this judgment before the lower court, your lordship, this case has already been decided, but the court did not appreciate it, overlooked this decision and disposes your case just by saying this, no, res judicata is not applicable here, the case is not maintainable one, or there is no cause of action. So, this would be a clear violation or equivalent to disposal of your case on a preliminary point of law. Preliminary, this is preliminary point, this is not final or something else. Preliminary, when, because this happens on the first date of hearing itself or during first stages of cases, the case is not maintainable. Res judicata, you take plea when, if you feel the party is again filing case against you, when you feel there is a cause of action, but the court is not accepting, no, there is no cause of action. So, these are preliminary point of law. Then in that case court can exercise power of remand, this one, sending back, and lower court can direct the lower court, try it again. Again trial will take place, or in the order sheet itself this will be mentioned there, what step has to be taken by the lower court now, because there is a direction of the appellate court. Appellate court, because they are judicially examining your case, they have to decide your case finally, because they find on the basis of your memorandum of appeal, they find this thing, yes, there is a mistake, what has been committed by the lower court or trial court. You can quote it trial court also, trial court or lower court. Second one, on the other hand, where the lower court dismisses the suit on the ground that plaintiff is estopped from proving his case. These are point of fact. Estopped, plaintiff is estopped from proving his case. It was motivated one, plea raised at the hearing was different from that raised in the plaint. It does so on a preliminary point of fact. Estopped from, like when lower court or trial court stops you from proving your case. Advocate basically brings evidence before the court. Ultimately court has to decide okay, this evidence is relevant or not, this witness is relevant or not. Out of list of witnesses also court finalize okay, suppose you give a list of 10 people, court will finalize to whom the court should call and to whom the court should not call, which evidence court has to appreciate, which documentary evidence court has to accept and which evidence court has not to accept. I am talking about estopped from proving his case. When you are estopped, when you are stopped from proving your own case, you should point out immediately, that should be on record, but you can go in appeal, first appeal. This can be a ground of first appeal. Court cannot say, trial court or lower court cannot say this thing, no Mr. Advocate, you cannot say this thing, you cannot produce this evidence, you cannot bring this witness before the court. If you feel, because this is your case, if you feel no, this witness is important, this piece of document is important, then you should produce it and you should get it recorded also. Court cannot deny this one, because this is your case, otherwise how would you prove? Because you are an advocate and you know this thing, which evidence is relevant one, which document is relevant one. Court cannot decide, court decides, there is a discretionary power, no doubt. Court can reject also, overrule also your objection, but at least you should raise objection, whether court accept it or not. Subsequently, if you feel aggrieved one, you can approach the first appellate court. Appellate court will decide how this is relevant. You can present your plaint before the appellate court also, but lower court cannot. I am telling you, when power of remand can be exercised by the appellate court, because through this power appellate court will remand your case before the lower court, and these are the points. Motivated one, just by saying no, this is motivated one, this is malafide one on the first date of hearing, because court can judge your language, but just by I mean body language also, just judge your behavior also, through behavior also, this is false or vexed claim. This kind of cases are coming, so that is the reason court are also cautious, no doubt. I am just telling you this one, this kind of things, how court can say or court can dispose your case on preliminary point of fact and preliminary point of law. Or second one, when court say no, this plea is something else, and what you have mentioned or what you have written in plaint, this is something else. Sometimes court can reject or court can dispose your case or try your case on this basis also. The plea must be same one, whatever you have mentioned in your plaint and whatever you are arguing here before the court, I mean, that must be same one, but that is not the criteria. Sometimes you, being an advocate, you people try to prove it through this argument and that argument, but court cannot say, but no doubt you should relate it, you cannot say absolutely, speak absolutely irrelevant over there before the court. Court has also dignity, court has also some duty, although this is your case, but still you have to be within the decorum, you have to be within the, maintain the dignity of the court, being an advocate. But just by saying this one, no, the plea, both the pleas are different, court cannot reject. If the court disposes of, this would become a ground of first appeal, or this would become a ground of remand. Court would exercise definitely, because appellate court is not sitting there, first appellate court or second appellate court will not examine the witnesses, will not examine the, that try the case completely. If they find no, there is a problem, there is injustice with the party, or this power has not been exercised by the court properly, or the case has not been tried by the court, lower court or trial court properly, then appellate court can reject your, I mean exercise the power of remand, send back the case again, okay, try it again, by saying this one, by direct court would appellate court would direct the trial court. This is power of remand, very important power, sending back the case. Again, first you have to understand the meaning of this win, from where to where the case is being sent. This is what you have to understand, power of remand. Power to issue, third power, power to issue and pass them for trial. Power to frame issues, frame issues, same thing. There are three things. When the lower court has omitted to frame any issue, this is first one, omitted to frame any issue, because court frames issues as per order 14 of CPC. There is a framing of issues, title of order 14, 14, that is framing of issues, and court frames issues on the basis of the plaint and the written statement. Pleading, I given you example also in my decree and order lecture, like if there is a suit for recovery of possession of, getting possession of immovable property, who is in possession, since how long he is in possession, whether possession is peaceful or not, this kind of issues, because this is the point of controversy. Out of your pleading, court finalize this one, what is the point of controversy, what is the point of adjudication, and court will invite evidence accordingly one by one. Chief examine and cross examination will take place one by one. So, sometimes lower court commit these mistakes, omitted to frame any issues, although this is the duty of the lawyers also. They must also they also must understand this one, whether the court has framed proper issues, because this is the issue of the concerned parties, the point of countries, the point of dispute, the point of the problem between the two parties, and immediately they should raise objection if lower court is not committing or lower court is not framing your issues properly. You can take date also for argument, but if you sign it silently and subsequently if you are saying no, your lordship, this was not the point of controversy, this is not the point of dispute, then that is not right approach. You should be vigilant, being an advocate, immediately when the court is framing issues, and sign that charge issue sheet after going through this one, whether your issue is proper one, plaintiff and defendant both the parties, whether there is a proper issue or not. If there is omission to frame any issues, then this power again can be exercised by the appellate court. Appellate court will say, direct the opposite lower court or trial court, go and frame this issue. Appellate court can also frame these issues, but evidence will be taken by the lower court or the trial court again. Case court will again exercise the power of remand, will send back the case. Second, to try an issue. Suppose issues has been framed, but the court has not tried it. Sometimes I have seen this one also. Sometimes court frames issues, but do not frame it, do not try all issues. Although this is the, again advocate has to produce the witnesses and the evidence, but if the court is not trying your issues, then advocate must point out this one before the honorable court. Your lordship, this is the issue and this must be tried, and this is crucial issue. Without deciding this issue, there can be no judgment or decision in this case, because you know better, advocates know better, parties know better what is the point of dispute between them. Sometimes this kind of mistake, this is covering unforeseen circumstances also. I am not saying you in always case this in all cases this happens, but this can also happen. Court can omit to frame any issues, court can not try any issue, or to determine any question of fact which is essential to the right decision of the suit upon merit. Court has to finalize this one, what is essential, your argument, your evidence will make it important one, will make it okay, this is really the thing, the point of controversy. So, power to frame issues and refer them for trial, where the lower court has omitted to frame these things, when power of remand can be exercised, and this is also power, otherwise also court, lower appellate court also can exercise this power and frame issues and refer them for trial. Third one, power to take additional evidence, rule 17, when appellate court can, although this is exceptional one, this power is very exceptional one, additional evidence. There are three conditions when appellate court can accept additional evidence also. The first one is where the lower court has improperly refused to admit evidence which ought to have been admitted. See this one, meaning of this in rule 27. Where the lower court has improperly refused, it means lower court sometimes or trial court sometimes commits these mistakes, which ought to have been admitted, but just the court is court, and just by saying this one, no, this is irrelevant evidence. But you know, if you have read section 11 of Evidence Acts, sometimes the same thing becomes, the irrelevant things becomes relevant also. But how the courts are taking, accepting, appreciating your evidence, this is a question of appreciation of evidence basically. Improper refusal, if you find there is a improper refusal, this evidence should be admitted, but court is rejecting, then this can be a ground of additional evidence before the appellate court you can take. Normally I have seen court says, lower court or trial court, you go in appeal, this court will not accept this evidence, then you can approach the first appellate court or second appellate court, then court will order this one, no, this evidence is relevant one. It varies case to case, but this situation can also be there. You have to, being an advocate or first year or second year student, you have to understand this one. There can be improper refusal, proper and improper. This is improper refusal. You cannot, being a judge, you cannot deny, lower court judge, you cannot say this one, no, this is, if the thing is relevant one, let the party, let the advocate should also, I mean advocate should also present their view. They should also produce this thing or present this thing, how this is relevant. This is called convincing skill. You should convince with your argument. If the court accepted it, it is okay. If there is improper refusal, what should be admitted by the court, but the court is not accepting, then this would be. Second one, where such additional evidence was not within the knowledge, this can also be ground of additional evidence, was not within the knowledge of the party or could not, after exercise of due diligence, be produced by him at the time when the lower court passed the decree. Sometimes this also can happen, because there are public document, there are private document. Private document can be in your possession, but public document normally, take example, suppose you get birth certificate for municipal committee or so other public document. So, that takes time, or sometimes also this is beyond your knowledge. Subsequently, if you come to know, no, this is also important evidence, and if you plead this thing before the court, before the appellate court, and appellate court accept it, then also additional evidence can also be accepted by the appellate court. Sometime even after exercising due diligence also you cannot produce, this can also be a ground of accepting, getting accepted additional evidence. Third one, where the appellate court itself requires such evidence either to enable it to pronounce judgment or for any other substantial cause. These three grounds are there. Sometime court also, no, if you really want to prove this one, then get this evidence, produce this evidence, then court can also require. So, these are the three conditions when improper refusal, because the power is power to take additional evidence what you have already produced, apart from those things evidence. If you want to produce some other evidence, then for this also, if these three grounds are there, then court can accept your additional evidence. Otherwise, these are the powers. First is power to decide case finally, second power to remand, very important and important power, sending back the case. Third one, power to frame issues and refer them for trial. Three situations where the lower court has omitted to frame any issues or tried any issues or not determining any question of law, question of fact. And fourth one, power to take additional evidence. Power to modify decree, this is also a power of appellate court. Appellate court can also modify your decree if they find the thing is there. Substitute the parties in case of misjoinder, non-joinder, striking out order 1, rule 9, 10 of CPC. You will find how to substitute the parties, all those things. Withdraw of proceeding, permit withdrawal of proceeding, this can also be inherent power, section 151. Section 151, withdrawal of proceeding and other powers. This is all power. There are few examples. With the help of these examples, you can come to know more about what kind of power can be exercised by the appellate court. An appellate court is empowered to reappreciate the evidence. First one, reappreciate whatever has already been appreciated but not taken into account, then appellate court can also reappreciate the same evidence what you have already produced before the trial court, whether the evidence is relevant one or not. Second, transpose or substitute the parties, permit the withdrawal of proceeding, return a plaint, memorandum of appeal, presentation to the proper court to allow amendments, to take notice of subsequent events, take into consideration changed position of law, apply the existing or changed law, order substitution, enlarge time for doing certain acts, etc. This list again is not exhaustive. Appellate court has very vast power, and really appellate court will, they judicially examine your case. If you convince the court, if you prove your case, then definitely you will get justice from the appellate court, if you feel you are aggrieved one. from the decision of the lower court. So, these powers you have to understand, and I will recommend one book also for this one. There is a Bayer Act, no doubt, without Bayer Act you cannot move CPC student, but there is a good book of on this civil procedure code, Takwani book. And apart from it also there are number of other books. If you understand the language, then I will say this is good one. These are the duties of appellate court. Duty not to interfere with decree on for technical errors, because ultimate the end of justice is important. Technical errors, technical things are not important, these are small things. Reappreciating the evidence, duty to record reason, this is also duty of the appellate court, recording reason, because without recording reason there will be a violation of natural justice, or the decision must be speaking one, speaking order, speaking judgment, there must be reason why you are giving this judgment. So, that is the reason we call sometimes if you record reason, the judgment is or the decision is speaking one. Decide case finally, admitted or dismissed as a whole, or it cannot be admitted partly. Appellate court cannot grant stay against the execution of decree if appeal is time barred. So, these are few duties of the appellate court, and this is the procedure of appeal. You can go through, just for the sake of your convenience I have mentioned it here. So, this is all about your appeal. Mainly I have focused on powers of appellate court apart from meaning and first appeal. And for second appeal I have given you case Chunilal Mehta versus Century Spinning Mill, and for additional evidence also there is another case, that is Bimla Gill versus Bimla and others. This judgment is also there. I mean, how additional evidence is a important thing, how court can accept additional evidence and other things, appealable orders, appeal by indigent persons. So, if you understand powers of appellate court and meaning first appeal and second appeal, then you will come to know first appeal before the higher court, second appeal before the high court, third appeal before the honorable Supreme Court. This is the provision of appeal, first appeal, second appeal and appeal to Supreme Court. So, thank you. This is all about your appeal. Thank you.